Now, the National Prosecuting Authority admits that it needs to tighten operations within its forensic capabilities on the Estina dairy farm saga. The NPA remains confident it had a strong case. After Worldview reporter Nomusa Pungola has filed this report.
Bloemfontein High Court Judge Lubsha's judgment on the seized Gupta family assets was a huge blow for the National Prosecuting Authority. The state has come to realization that there is a need to strengthen its forensic capabilities. This is after legal heavyweights Vim Trangover, a senior counsel, failed to stop the bid to unfreeze the 250 million rands worth of Gupta family assets. Judge Lubsha found that crucial evidence was left out by the state and that the money flow was not enough for the prospect of a successful prosecution in the near future. However, the state remains confident that they have compelling evidence they will present in the criminal case.
In a recent judgment by my brother Jordan J. in a preservation order application in terms of Section 38 of POCA, where some of the present applicants were also involved as parties, the court came to the same conclusions. Jordan J., however, had the benefit of an affidavit by the Bank of Baroda explaining the mechanisms of the pool account. When the present matter served before me initially, that affidavit was not included in the papers filed by the NDPP. At the hearing of the present application, I allowed that affidavit in the interest of justice and fairness to form part of the papers.
This does not affect the criminal case. We're going ahead. They will appear in August. He was not called upon to adjudicate on the strength of the criminal case. He did not get a copy of the docket. There were no witnesses called. There was no documentary evidence that was presented before the court that talks to issues of criminality.
On Monday, the Bloemfontein High Court ordered that the asset forfeiture unit return the assets which were critical in the state's case. These shambles have cast a shadow of doubt on the NPA's ability to have a successful prosecution in the criminal case. Nomusa Pungola for Afro Worldview, Midrand.
Joining us now live in studio is Professor Shadrach Guto, who is our constitutional expert. And over the phone, we're also joined by Mr. Wayne Duvenage, who's the outer chairperson. A very warm welcome to you both, gentlemen.
Thank you.
Great, let's launch right into it. Now, the case that the NPA presented in front of the Bloemfontein High Court is said to have been so rushed, as in it was not professional and it was not thorough. Which then brings us to the question of what could have motivated them to present such a case. Was it public opinion because they were under pressure publicly, or was it political pressure? I'd like both of you gentlemen to weigh in on this one.
Analyzing the situation, it does seem that there's a rush at the moment, a populist rush to be able to say there's state capture. And one of these Estina farm in Free State province is one of those where there has been state capture. But what does it mean? So I think everybody is rushing around to try and say we want to stop state capture. In other words, interpretation of the former public protector advocate Tuli Madonsela's report is being used all over the place for political reasons, and it is not being followed properly as it should. And I think it was a good report, but it was narrowly focusing on the Gupta families and the role they have been playing. And in this particular case, the farm was one of those where the public protector focused on. So it is an easy political football which is being played around by all over the place. And I'm glad that the court, the High Court in Bloemfontein, has come up to cut it through and say, let us not just go wobbling around trying to focus on the Guptas, and we don't even have concrete evidence of what really happened. And that farm in particular, what the court decided was that, there didn't seem to be enough evidence if it was to be prosecuted beyond reasonable doubt, because this is a criminal case. And I think the court did something very important for us to reflect properly on this attack on the Gupta family, and also on the question of what does state capture really mean, as the former public protector indicated.
Let me bring you in as well, Mr. Duvenage. Public opinion or political pressure?
Look, we believe that the AFU has not done its homework properly. Forensic audits, you've got to demonstrate very clearly where the money has come from and follow that money to show how the proceeds have benefited the Guptas in this case. And unless they can do that and do it properly, the judge has no option but to release the seized assets. It doesn't mean to say that this case is jeopardized in the August matter when it gets to court. But for a forensic audit that has to be done, if you want to seize and freeze assets, then you have to provide the evidence very clearly, not half-heartedly. And we don't believe they've done that properly. They're rushing into these matters now. For years, they've sat back because the barriers have been put in place during the Zuma era. We've seen very little work of the assets forfeiture unit. If you go back to 1999, when it was set up and Willie Hofmeyer was there, billions and billions of rands, many successful cases. That has dissipated over time. Now the assets forfeiture units and the NPA are starting to fire up again and do this work, but they've lost a lot of talent. They've lost a lot of forensic auditors. They're right down to the bare minimum. In fact, I don't think they've got the sufficient capacity, and this is the result and outcome of this type of conduct.
Now, sir, the NPA has come under fire following this judgment, and one word that's been used over and over again is incompetent. Is it fair to judge them as incompetent just based on this one case?
Well, in this particular case, there's incompetence. But I don't say that the NPA is incompetent throughout. There are areas where it has done good work. There are areas where the assets forfeiture units has done good work. But in this particular case, I think everybody is rushing to try and score points. And they ought to really read and interpret properly the rights that individuals, whether natural or corporate, do have under the Constitution. They are persons, and therefore, if they are accused, then all provisions in Section 35 of the Constitution apply. Presumption of innocence. They have to be told what is happening and so on. So the presumption of innocence is core to the criminal justice system in the country. Of course, you do have also cases which necessarily do not go to the criminal prosecution. They will go to other independent tribunals under Section 34 of the Constitution. So I think we are confusing a lot of things here, and I think that both the National Prosecuting Authority and the Assets Forfeiture Unit, which is part of the justice system, ought to wake up and stop playing politics and engage in proper analysis before they can be able, because all it does is damage people's reputation and so on. And that's not proper. because the people involved can actually sue them for damaging their reputation.
Mr. Wayne Duvenage, let me bring you in as well. Maybe not incompetent then, but now we have seen the people at the helm of the NPA being mired in a controversy. Has this contributed maybe in bringing down this low confidence, lack of confidence rather in the NPA as a body?
Yes, it has. I mean, when you start failing not once, but twice or three times in a very short period of time, the public's view of the competence of the NPA and the Assets Forfeiture Unit does take a blow. We need these institutions to do their work thoroughly and properly. That's not to say that there's total incompetence, but what they need to do in forensic audits is different types of crime. In crimes of fraud and corruption, you have to follow the money, and you have to have a skill set which is, it's not an easy one to come by. The people that do this work, highly trained, they know exactly what they're doing, and the more experience they have, the better they are at this. It's not the type of work that a typical investigator can do. So we're a bit concerned. We've also seen how they rushed into one of Arthur's cases on the rehabilitation funds and nearly scuppered our whole case, which we had already frozen, and this wasn't a matter for the AFU. They shouldn't even come into the case because there were no proceeds of crime there. It was just the fees and funds on the rehabilitation of the mines that had to be frozen, which had already been done, and they're not thinking and they're not applying their minds enough on some of these matters, and that's a bit of a dangerous situation to be in.
Now, we've seen a desire as well to go the private prosecutions route in the recent part. A case in point is with Solidarity going after Julius Malema on the on-point tender debacle, as well as Brian Molefe. How does this play to building trust in the work of the NPA? Let me start with you, Mr. Duvenage, because I know you're very close to this particular one.
Well, private prosecution cases can only be bought if a non-prosecute certificate has been given. In other words, the NPA have decided to abandon the case for whatever reason they cite. And if another party, a private party, wants to bring this case and continue because they believe there's sufficient evidence and they get the permission to do so, then they can proceed. This doesn't happen very often. It would be a bit embarrassing for the NPA to give up a case that they believe has got no merit and then to lose it. We've seen a couple of cases like that, but very few and far between. So it'll be interesting to see how that takes place with Solidarity. We're not working on that case. We don't work with Solidarity. But we will bring a private prosecution as and when it is required, we believe so, but not at this stage.
Now, you as ITA have been calling for the Gupta family to be held accountable. Are you doing anything as an organization to pursue this?
Oh yes, absolutely. I mean, we've laid charges, a number of charges in the past, not only against the Guptas, but against other people related to them, their lieutenants, so to speak, the Anuj Singhs, the other people within the Transnet and Eskom and so forth. So there's a number of cases, and we would like to see people held accountable. If you follow the money and you look at the investigations that have been done and the evidence provided, it's very clear that there is a lot of fraud and corruption that has taken place, and gross maladministration by people in positions of power. They need to be brought to book, and that will unfold as the NPA and the Hawks start to gain their credibility, gain their expertise. We believe over the next 4 to 5 years, a lot of very wealthy people will not be sitting in comfortable positions anymore.
Okay, let me bring this question to you as well, Professor Guto. What is your take on the route of taking public prosecutions?
Well, I think that it is important. There is obviously independence of the prosecuting authority and the Constitution, and therefore whether to prosecute or not relies with the Director of National Prosecutions to decide, together with other regional and prosecutors and so on. But at this particular moment, this is a signal to Solidarity, Afro Forum, and others who are trying to rush to score points. Sometimes they're right, and there are many times when they are wrong. And I think that what we are dealing with here is a situation where a signal has been sent by the court that a proper court will actually go with the evidence that is before them, not just what you have, affidavits and, because some of them are sworn affidavits, but they are not correct. And the courts have to look at them. It is not because you have sworn an affidavit and therefore it is evidence. No, it is not evidence. The court will look at what is the evidence beyond the affidavit. And I think that's where some of the problems come. And in this particular case, private prosecution can be brought, and there's a right of people to do so if the National Prosecuting Authority does not go ahead with prosecution and you think you have a good case, you should have a right to be able to go and do private prosecution. But if you are doing it for political reasons, to score points and so on, that's up to you, but it is up to the court to be able to look at all of that. Secondly, I think that this particular case and the ruling by the High Court judge in Bloemfontein is important because it does also at the same time say the Gupta brothers, they are free to come to South Africa, in and out. And the idea that when they enter South Africa, they will go to jail is now being removed. So it has cleared a lot of points here, which I think we need to look at and say this is the justice system in action.
Great. Gentlemen, in closing, yes, the NPA has taken quite a knock. Its reputation has taken quite a knock with this judgment. So very briefly from both of you, and I'll start with you, Mr. Duvenage. What can the NPA do to just increase this level of confidence that it's lost so drastically after this judgment?
Well, we don't believe they'll be rushing too quickly into the next case. One worries, though, that they'll become gun-shy and not take up any matters that they should be because they need to continue doing their work. What they need to do, though, is to build their expertise and competence, especially in the forensic audit space. If they get that right and they're a lot more thorough and be more diligent and take the time if need be, I think they will start being far more successful.
All right. Thank you so much, Mr. Duvenage. That was Outer Chairperson Wayne Duvenage. You, Mr. Guto, one last word as well.
All I can say is that we have got really purification or unlocking of the propaganda going around the Guptas. They are corrupt, they have corrupted everybody. No, they may have corrupted a few people. But state capture is a much broader issue than just the Gupta family, because I think they're looking at it from a narrow perspective, because the public protector was only dealing with a specific case and not with state capture generally. And I hope that we are going to discuss this, and some of us who are academic scholars, intellectuals, will begin to do research and write and inform the public about it, rather than just going around with throwing words around and confusing people even further than they have already been confused.
All right. Mr. Professor Shadrack Guto, a constitutional expert there. Thank you so much, sir. Thank you so much for taking the time to give us some insight into this issue.